Matthew, thank you for taking the time to speak to the National Rifle Association. You were caught in this modern dilemma that we've been talking about a little bit, but I'm still confused by. So let's begin wherever we can begin. You're being sued by California. You've been brought into San Francisco Superior Court for 3D printed guns and being somehow combined or connected to other people online who talk about 3D printed guns and maybe share plans for them and so on. You pick it up from there, because I'm confused, and I think most of us are confused.
Yeah, and the reason you're probably confused is because it's confusing. Unfortunately, when I explain what happens, you probably won't get any less confused. And basically, long story short, what they're doing is silly. So essentially, California's theory in this lawsuit is that there's this organization, right, that is coming together and has this plan to distribute all of these gun information into California. And they're alleging that the people they've sued, which is me and a couple of my friends, are at the head of that. And that it's all, everyone's an alter ego of each other. And that's just not quite true. So the reality is that there's tons of people online, tens of thousands of people who are interested in home gunsmithing and home gun design. They've kind of come together across a lot of different loose collectives, and there's a lot of different names they go by. And as far as I'm aware, there's not any actual membership structure or actual formal organization behind any of these groups. For example, the Gatalog, as they assert, isn't like the NRA. There's no member that have a card. There's no board of directors. There's no nothing. It's kind of just a group of hobbyists associating around an idea. And the idea is home gunsmithing. It's that simple. But as for how they've attempted to rope me into it, well, the funny thing is, a couple years ago, me and my friends decided it would be cool to make a print newsletter about safely doing home gunsmithing. And we decided we would create a nonprofit to try to do this. And so we incorporated the Gatalog Foundation, LLC. And then nothing happens. We didn't make the newsletter. We never had a board meeting, never had any money, never transferred anything. But I guess just through a combination of wishful thinking or just a lack of any pre-suit investigation, California decided that this
was
failed.
anyone on the website or something? How did they even find out that was a thing? You were just a registered nonprofit, and they threw a search, found that.
Yeah, they found that, and there was a draft website for the newsletter, right? Which I don't even know if it was ever published, but the simple fact is nothing ever went through with it. So, like I said, I think they just searched that name across corporate records, and they were like, "Oh, that must be it," because it is kind of a unique name, Gatalog, right? It's kind of like it's a catalog but gun, but that's
right. So you're a loose group of people that like home gunsmithing, and that's a common thing, and that's a known thing, and that's since the founding of America and before. People have made their own guns. I know lots of people get their own guns. It's a normal thing. There's a process you can go through even to register that gun and get a serial number on it. That's the where you want to go with that firearm. So that's all legal and law abiding, but they're trying to get you wrapped up into ghost guns, illegal 3D gun printing according to California law, right? Is that where this is?
Yeah. So what's interesting here is the last time I published a gun design was years ago. These things take time to make. And in fact, there's one of the co-defendants hasn't published a gun for 3.5 years. California's law has been in effect for about a month. And California's law basically says that it is illegal. So not only a crime, but civilly, there's a civil penalty, which, so they're not suing us in criminal court. This is a civil case. they're saying that we should be held liable for fines for making, and what the law says is computer gun code, or computer code for making firearms. And that's really confusing too. And then a lot of people kind of react to that and they're like, oh, well, code is free speech, code is free speech. Because there are cases that have specifically said that, like, yeah, lines of code are eligible for First Amendment protection, but you kind of have to pump the brakes. Because the way California defines, firearm code or firearm manufacturing code includes digital models, so like a 3D sculpture, instructions, so literally a PDF, right? Written instructions. And then there's a catch-all that's any other file that can be used to manufacture, stored and displayed as a digital model. So they're not going after like the machine code that's actually used on a CNC machine to make a gun. They're defining as gun manufacturing code literally instructions and 3D models, which I think has obvious First Amendment problems, not only, and Second Amendment problems, because, and that's why I've been so glad that the NRA is taking such an interest in the case, because the NRA can see that these files, right, the instructions, if California can regulate access to the instructions, not just by California, but with this lawsuit, what they're saying is they want to regulate the entire internet worldwide. That would mean that you'd be cut off at the heels from making a gun at home. And I think most of us can agree that if you have a right to keep and bear something, it necessarily subsumes the right to acquire it. And there's only one way to get something that doesn't involve getting someone else's permission, right? And that's to make it yourself. So California's posture in enforcing this law, which basically the law says if it can be accessed by somebody in California who doesn't have a manufacturing license, it violates the law. So basically, is it on the internet? Right.
Right. Because you're not even Californian.
I've never been in California. I have no interest of ever going there, especially not now. But
right. But they're still coming after you for code and others. I mean, did you make 3D print models of these things? Is that where they're going?
So the only things that me and my friends have put out were literally instructions, right? Like a PDF with images, text, and then a digital model. So yeah, it's a 3D model, but it's not manufacturing code. There's no density. There's no information in the model that you can just slap onto a CNC machine and make yourself. The user has to come up with those parameters on their own. Of course, kind of guide them along the right way to pick the right parameters, but it's up to the user to scale the model, to determine what material and what infill settings and the strength settings that they're going to put in. That's all on the user. We literally share the digital sculpture, for lack of a better word. It's a mesh, right? So if you've ever played Call of Duty, right, and you see the gun in the character's hands on the screen, the thing we put out is the same thing. It's just a 3D mesh.
Right. Yeah. Well, this is the kind of nonsense that happens when instead of going after criminals, you go after things like this. In this case, the First Amendment infringement. I don't think the Supreme Court, you tell me, I'm not a lawyer, you are. I don't think the Supreme Court has ever decided whether computer code was speech.
So there's been a few cases that came close, but I'm not sure that the Supreme Court has had that exact holding. Mm-hmm. There's certainly been cases where the court was analyzing things that were much closer to what normal people would consider code than what we're dealing in. But remember, this is only code to the extent California defines code so broadly. For example, if you wrote a poem, right, and you wrote it in Microsoft Word, and you hit Control S and you saved it to your desktop, what would you call that file on your desktop? Right. You'd probably call it your poem. You wouldn't call it your computer.
You call it a document maybe, but right.
You wouldn't call it computer code for displaying a poem. No. So it's very disingenuous to suggest to call it computer code. because this is stuff that's meant to be understood by a human. It's not stuff that's meant to be, terminally interpreted by a machine. And I think they're using that wording to try to soften what they're actually doing, because ultimately it's a book ban, right?
Right.
It's like, right. That's what it is.
This makes me think of encryption and how it was outlawed in the 90s. But it was Phil Zimmerman, right? Who pretty good privacy.
Yep.
And he printed the code in a book in order to get us encryption, and then had First Amendment protections. And I think the government withdrew from the case because they didn't want to lose at that point.
Yep. And then there was also Bernstein 3, right? Which was also an encryption case. And people were, that was ITAR. So they were saying, oh, you can't export this stuff. So people were printing the code on a t-shirt and flying outside of the country and then coming back in and saying, did I violate ITAR? And then during the court hearings, people were coming in with the shirts, with the code on it and sitting in the hearing. So it kind of, it was a really entertaining display. But I think that what we're dealing with here is exactly as ridiculous. And what's funny is they kind of threatened to have the same thing happen, because there's one guy, Chad Davis, who is an expert on actually minimizing the size of the code to make the map model. And so he's made some code that ultimately creates a model that you could absolutely fit on a t-shirt. And here's the other thing.
Okay.
What they're really after is the models. I think that they know that they can't ban, right, PDF instructions and things like that. At least, God, I hope they know that. Right. But here's the thing about digital models. They're stored, at least the digital models that are common in this context, they're stored in plain text. You can literally have a paperback sized book with the whole model in it verbatim. I think that the way the California law is written would ban that.
Wow. Well, 3D printing is just so useful. If you have a firearm that is no longer made and it has some sear or whatever part breaks, using a 3D printer to print that little part through your gunsmith and to fix that firearm, it's super useful.
Yeah, it happens. I mean, it happens all the time for me. I'm a collector of obscure and obsolete firearms, and yeah, if I didn't have 3D printers, there's a lot of them that I wouldn't be able to use. For example, we've a lot of people don't know about the Armalite AR-17. It's a really, really slick shotgun, and they were made with really brittle polymers that didn't hold up for 70 years. And so now, instead of just not shooting the gun, we can just print, my buddy printed a whole stock for it, and it shoots great.
Yeah, super useful. If they were to win in a case like this, and I can't imagine that they would win, but if they would win in a case like this, how would that then shut down gunsmithing across the country?
I think if they win in this case, right, we have to remember they're saying, the people of the state of California are saying that they can go to Florida, where a Floridian person is talking about making guns, because that's what this is. This is speech about making guns, and shut that down to prevent someone in California from hearing or seeing it.
Right.
I think we already know what they've done in other contexts, and I think it would be a complete nightmare. I mean, look at all of the website banner things you have to click on just because of California law. California isn't new to projecting its own interest onto the rest of the country. But I think if they win in this instance, it would be crushing, because this is, again, the fundamental instructions, right, that are needed for home gunsmithing. Like you said, since the beginning of this country, there was a rich history of people home gun making, including like a precursor to 80% parts. People would buy the lock work from Spain or the Netherlands and make the easier to make parts. And that's kind of similar to what 80% type stuff is here now. But that's been going on since the beginning of the country. I bet you that they had pamphlets and letters and books that they were looking at when they were getting started. If we can't have the same thing in the modern version, right? Like, I mean, I'm sure some of you out there still go to a library, but I think most people, when they want to read something, they find the PDF. California is trying to tell you that you can't have that wherever you are if it could be also accessed by someone in California, which is just a really chaotic and bizarre way to keep your own people away from information, right?
Yeah. Hey, and this is a local court, right? This is San Francisco. If they win there, then you have to go on appeal, right?
Right.
To a higher court and so on. The money that will cost you and other defending in, I would call it a frivolous case like this, has to be extraordinary. And so they're putting you in a position where maybe they're hoping you're going to back down, or others will just stop because they don't want to deal with the possible litigation costs.
Yeah. The interesting thing is that they included a known gun rights attorney in their defendants. So I feel like the calculus is a little different for us because I fight this type of case for fun. So, but aside from that, yeah, the costs are huge because I'm not barred in California. I'm not going to be barred in California. We need help from California attorneys. And it was stressful, of course, until the NRA stepped in to help. The NRA is basically assured me that they're going to handle it. And also, quite interestingly, keeping me involved in litigating the case and really committed to securing a win. So when I talked to, leadership in the litigation counsel's office, the clear statement was, no, we want to win this. Right. So honestly, between that and some scripture that my friend sent me right after I got served, all the stress just melted away. It was, I'm just not worried about it. I feel like this is a fight that has to be fought. It was going to happen at some point. And, they could have picked they could have picked some 18-year-old kid that's designing this stuff, in his mom's basement. That's just at the start of his hobby. So, I thank God that God picked us for this fight because we're ready, and that God gave us the relationship that we have with the NRA and Joe and you guys to make it not life crushing.
Okay. Where can people go to help if they can, or to find out more about this case? How can they contribute or whatever?
Yeah. So I actually don't know.
Okay. The NRA, as they're behind you, as they would be, is legislative action and all the great people there.
Yeah. So there's a lot going on right now, and we're very, we're at the early stages of this. This just happened. It's still a whirlwind. So, I don't know when a site will be up that has specific information just about this case, but of course, NRA ILA has been really throwing their weight behind us. That's huge. We do have a countersuit where we are actively suing California. But if you want to see more from me and my friends that are actually involved in this case, I'm actually on YouTube on Fudbusters and Fud Blasters. My friend John, he's Ivan the Troll. You can find him on Patreon, Ivan the Troll, and you can find me on Patreon, Fudbusters. And then Alex is Control Pew, and he has a website, controlpew.com, which apparently California doesn't want access by Californians. That's places where you can go to find all of us.
Well, this isn't just the cutting edge of firearms technology. This is the cutting edge of their fight for freedom. So please keep talking to us. I'm glad our attorneys are in your, as they would be, in your corner, fighting this good fight. But keep talking to us. Let us know, let our members know where this is going.
Absolutely. No, I'll be ecstatic to hopefully bring you guys as much good news as possible. But I want you guys to know that one question I've been getting a lot is, will you take a settlement? Will you take a settlement? that wouldn't accomplish the goals that we have. And the goals that I share with NRA ILA is to make sure that they can't do this to anybody else. So that's what we're in for, and it's what we're going to fight for all the way up.
You need a precedent. Thank you, Matthew.
Thank you.